Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we've uploaded this 10-question practice set, and we do so every day at 8 a.m. Eastern Standard Time. You can do one per day, do as many as you want per day. Our goal is simply to be there for you and help you prepare for this exam so you can join us in the legal profession subsequently afterwards. Let's jump right into question number one. And if you like the content, don't forget to like, subscribe, and click the notification bell so you can be updated every time there's new content that's uploaded.
Jackson and Brannick planned to break into a federal government office to steal food stamps. Jackson telephoned Crowley one night and asked whether Crowley wanted to buy some hot food stamps. Crowley, who understood what hot meant and that it meant stolen, said, "Sure, bring them right over." Jackson and Brannick then successfully executed their scheme. That same night, they delivered the food stamps to Crowley, who bought them for $500. Crowley did not ask when or by whom the stamps were stolen. All three were arrested. Jackson and Brannick entered guilty pleas in federal court to a charge of larceny in connection with the theft. Crowley was brought to trial in the state court on a charge of conspiracy to steal food stamps. On the evidence stated, Crowley should be found, A, guilty, because when a new Confederate enters a conspiracy already in progress, he becomes a party to it. B, guilty because he knowingly and willingly aided and abetted the conspiracy and is chargeable as a principal. C, not guilty because although Crowley knew the food stamps were stolen, he neither helped to plan nor participated or assisted in the theft itself. Or D, not guilty because Jackson and Brannick had not been convicted of or charged with conspiracy, and Crowley cannot be guilty of conspiracy by himself. Take 10 seconds and choose what you believe to be the best answer now. If you chose option C, you're off to a great start. Not guilty because although Crowley knew the food stamps were stolen, he neither helped to plan nor participated or assisted in the theft itself. Conspiracy requires an agreement to commit a crime between two or more people, an intent to enter into an agreement, an intent to pursue an unlawful objective, and an overt act in furtherance of that conspiracy. Here, Jackson called Crowley to see if Crowley wanted to buy these hot food stamps. Crowley knew what hot meant and that it meant stolen, and he agreed to buy them anyway. However, Jackson did not mention that Jackson and Brannick still had to go out and steal these food stamps. Crowley had neither the intent to enter into an agreement to steal the food stamps nor the intent to steal the food stamps themselves. More importantly, he didn't have the knowledge that they weren't stolen already. Crowley may be guilty of receiving stolen food stamps or possession of the stolen food stamps, but he's not guilty of conspiring to steal the food stamps themselves. Therefore, Crowley should be found not guilty because although Crowley knew the stamps were stolen, he neither helped to plan nor participated or assisted in the theft. Let's look at the three other options and analyze those. A, guilty because when a new Confederate enters a conspiracy already in progress, he becomes a party to it. The problem with this answer is the fact that Crowley was not aware that the crime hadn't in fact occurred. Even if he knew they were stolen, he didn't know they hadn't been stolen already. So the reality is that if he participated as part of the crime, he didn't participate in any knowing way, nor did he participate in any intelligent way. He only simply agreed that he would purchase them afterwards or purchase them even if they had already been stolen. So that being said, he could not be deemed a part of the conspiracy because he did not take any overt act, nor did he intend to take any overt act. So he's two levels removed. B, guilty because he knowingly and willingly aided and abetted the conspiracy and is chargeable as a principal. In our analysis of A, we looked exactly at this. He did not, in fact, aid or abet the conspiracy. He wasn't even aware that there was a conspiracy to steal the items because for all he knew, these food stamps could have been stolen by someone else and presented to Jackson and Brannick, who now are brokering them to him. Crowley would have no idea where they came from, nor, more importantly, the fact that they hadn't been stolen yet. So as a result, A and B are out as possible answers. D, not guilty because Jackson and Brannick had not been convicted of or charged with conspiracy, and Crowley cannot be guilty of a conspiracy by himself. Why that is true overall, the reality is that the other individuals do not have to, in fact, be charged. There is the idea of prosecutorial discretion. The prosecutor has a right to choose who they wish to go after. Here, the other two individuals were in fact federally charged by the different sovereign and were convicted, given that they pled guilty, arguably Crowley could be charged as part of a conspiracy, and so long as the accusatory instrument properly makes out that there was a conspiracy with other individuals, those other individuals don't necessarily have to be prosecuted with the theory of prosecutorial discretion. That being said, D would not be an appropriate response, and C would be the only appropriate response left. Question number 2, a newly enacted state criminal statute provides in its entirety, no person shall utter to another person in a public place any annoying, disturbing, or unwelcome language. Smith followed an elderly woman for 3 blocks down a public street, yelling at her ear offensive 4-letter words. The woman repeatedly asked Smith to leave her alone, but he refused. In the subsequent prosecution of Smith, the first under the statute, Smith, A, can be convicted, B, cannot be convicted because speech of the sort described here may not be punished by the state because of the First and 14th Amendments. C, cannot be convicted because though his speech here may be punished by the state may not do so under this statute. Or D, cannot be convicted because the average user of a public street would think his speech or action here was amusing and ridiculous rather than annoying. Take 10 seconds and choose the best answer now. If you chose option C, boy, are you a contender. Good job. C, cannot be convicted because though his speech here may be punished by the state may not do so under this particular statute. While fighting words are considered unprotected speech that may be punished by the state, all laws prohibiting fighting words are generally unconstitutionally vague and overbroad. Due process requires a statute to be clear enough that a person of ordinary intelligence will be able to understand what the statute in fact prohibits. Therefore, a statute is vague if a reasonable person cannot tell what type of prohibited speech is in fact prohibited. A law is unconstitutionally overbroad if it punishes speech that is constitutionally protected. In this case, the newly enacted criminal statute provides no person shall utter to another person in a public place or any annoying, disturbing, or unwelcome language. Since the statute does not define these terms, the statute is in fact vague. A reasonable person of average intelligence would not be able to understand what the statute prohibits. Therefore, Smith cannot be convicted under the statute. Let's look at the 3 other options and analyze those. A, can be convicted. First of all, the moment you see something as conclusory on the bar exam, you should assume that the answer is wrong and jump to eliminate the other options if possible. If you are able to clearly eliminate the other options, then and only then do you choose such a conclusory answer. We're going to move past it and we're going to assume that that will be left towards the back end while we do the analysis on the others. B, cannot be convicted because speech of the sort described here may not be punished by the state because of the First and 14th Amendment. This is clearly inaccurate because multiple states already have legislation, in essence, limiting disorderly conduct. Here, the person stood in public, followed someone, and yelled slurs at them or inappropriate 4-letter words that could theoretically be seen as disorderly conduct or many other potential crimes such as harassment or anything of the sort. So that being said, B is not likely to be a correct answer because the behavior of the type here is barred by legislation in many states and in many locations. Let's look at option D. Cannot be convicted because the average user of a public street would think his speech or action were amusing and ridiculous rather than annoying. The problem here is that the average user or the other people on the street are irrelevant because as the statute is worded, it's the listener who decides whether the speech was in fact disturbing or unwelcome or annoying. So as a result, it is a completely unilateral interpretive standard. It is what is understood or what is felt by the person receiving the statement. The issue here would be that arguably, if this is the standard, then any person walking down the street who decides to attempt to have a conversation with a potential suitor, that could arguably be deemed as language that violates the statute. I can imagine the typical construction worker that one thinks of, and a lovely young lady walking by and the cat calling. Theoretically, that behavior would be made criminal under the statute because, for the most part, the young lady usually doesn't respond too positively to it or doesn't feel fantastic about it. So as a result, this type of behavior would be criminalized under the statute, and obviously this type of speech is not intended to be limited nor protected against. So that being said, it's another reason why the statute would be unconstitutionally vague. We're looking at also reasons why B and D would not be appropriate answers. Now, A can be convicted. The issue here would be that while the person could theoretically be convicted for the behavior presented, the question is, will they or could they be able to be convicted under this statute? So as a result, C would be the best telling of this situation because it does factor in the question or the issue of the fact that this particular statute may not be one under which this defendant would be able to be convicted under. So C would be our correct answer. Question number 3. Pace sues Def Company for injuries suffered when Pace's car collided with Def Company's truck. Def's general manager prepared a report of the accident at the request of the company's attorney in preparation for the trial and delivered the report to the attorney. Pace demands that the report be produced. Will production of the report be required? A, yes, because business reports are not generally privileged. B, no, because it is a privileged communication from client to attorney. C, no, because such reports contain hearsay. Or D, no, because such reports are self-serving. Take 10 seconds. Choose the best answer now. If you chose option B, you'd be correct. No, because it is a privileged communication from client to the attorney. Any communication between attorney and client or their representatives intended by the client to be confidential and made in an effort to obtain professional legal services is privileged in all criminal and civil proceedings unless the privilege is waived by the client. An objective, reasonable person standard of intent is used to determine whether a communication was intended to be confidential. Here, Def's general manager prepared a report of the accident at the request of the company's attorney in preparation for the trial itself. The intent for this report to be confidential is objectively reasonable. Therefore, production of this report will not likely be required because it is in all likelihood going to be deemed a privileged communication from client to attorney. Let's look at the 3 other possible options. A, yes, because business reports are not generally privileged. Yes, that is true, but when business reports fall under the attorney-client privilege, then they're not protected as business reports, but they're protected as attorney-client work product. C, no, because such reports contain hearsay. The fact that they contain hearsay would arguably be irrelevant because generally, as you noted, or as option A would say, they in all likelihood would fall into the business reports exception. So as a result, C is not likely true. And D, no, because such reports are self-serving. Whether something is in fact self-serving is usually not a standard on which it should be or would not be produced. So we can exclude C and D immediately. A simply ignores the fact that this is not just a typical business report and instead now a privileged communication because it was requested by the defense attorney in preparation for trial itself, which is literally the epitome of a description of an attorney-client work product. As a result, B is the only correct answer. Question number 4. Landover, the owner in fee simple of Highacre, an apartment house property, entered into an enforceable written agreement with Van Meer to sell Highacre to Van Meer. The agreement provided that a good and marketable title was to be conveyed free and clear of all encumbrances. However, the agreement was silent as to the risk of fire prior to closing, and there is no applicable statute in the state where the land is located. The premises were not insured. The day before the scheduled closing date, Highacre was wholly destroyed by fire. When Van Meer refused to close, Landover brought an action for specific performance. If Landover prevails, the most likely reason will be that option A, the failure of Van Meer to insure his interest as the purchaser of Highacre precludes any relief for him. B, the remedy at law is inadequate in actions concerning real estate contracts, and either party is entitled to specific performance. C, equity does not permit consideration of surrounding circumstances in actions concerning real estate contracts. Or D, the doctrine of equitable conversion applies. Take 10 seconds. Choose what you believe to be the best answer now. If you chose option D, the doctrine of equitable conversion applies, you'd be correct. Equitable conversion is a doctrine of the law of real property under which a purchaser of real property becomes the equitable owner of title to the property at the time they sign a contract binding them to purchase the land at a later date. In equitable conversion, the buyer becomes the owner when the land contract is signed, so the buyer bears the risk of loss unless the contract expressly provides otherwise. Here, the equitable conversion doctrine provides that Van Meer became the equitable owner of Highacre when the agreement was in fact signed. This means that Van Meer bore the risk of loss from a fire since the agreement was silent as to the risk of fire prior to the closing. Therefore, if Landover prevails in an action for specific performance, despite Highacre being wholly destroyed by fire, it is likely because the doctrine of equitable conversion applies. Let's look at the other options here. A, the failure of Van Meer to ensure his interest as the purchaser of Highacre precludes any relief from him. Given the fact that he did not own the property, it would be impossible or improbable that he'd likely be able to insure it, so that would be inappropriate. Now, however, if he did have an interest, the moment that the agreement was signed, then we're led right back to D being, in fact, the more appropriate answer. Let's look at option B. The remedy at law is inadequate in actions concerning real estate contracts, and either party is entitled to specific performance. That actually simply does not make sense because we have an entire body of legislation attempting to be adequate and attempting to make each party whole to a contract. So B would not be an appropriate answer overall. C, equity does not permit consideration of surrounding circumstances in actions concerning real estate contracts. Again, does not make very much sense because at the end of the day, if the property in fact does not exist, can the purchaser be forced to purchase at the original price the property which no longer exists? That would not make sense, and it defies any rules of equity that I can think of. As a result, D would really be the only possible correct answer here. Question number 5. Passer was driving his pickup truck along a lonely road on a very cold night. Passer saw Tom, who was a stranger, lying in a field by the side of the road and apparently injured. Passer stopped his truck, alighted, and upon examining Tom, discovered that Tom was intoxicated and in danger of suffering from exposure to the cold. However, Passer returned to his truck and drove away without making any effort to help Tom. Tom remained lying at the same place and was later injured when struck by a car driven by Traveler, who was drowsy and inattentive, had veered off the road into the field and hit Tom. Traveler did not see Tom prior to hitting him. If Tom asserts a claim against Traveler, will Tom prevail? A, yes, because Traveler was negligent in going off the road. B, yes, because Tom was in a helpless condition. C, no, because Traveler did not see Tom before Tom was struck. Or D, no, because Tom's intoxication was in fact the cause of the harm. Take 10 seconds. Choose the best answer now. Well, that was an easy one. You should have chosen option A, yes, because Traveler was negligent in going off the road. Remember, to establish prima facie negligence, the plaintiff must prove a duty, a breach of the duty, causation, and damages. The duty of care is a legal duty requiring the defendant to act according to a certain standard to protect a plaintiff against an unreasonable risk of injury. A duty of care is owed to all foreseeable plaintiffs, and the extent of this duty is determined by the applicable standard of care. The basic standard of care is a reasonable person acting under similar circumstances. Here, Traveler was driving while being drowsy and inattentive when he veered off the road into the field and hit Tom. who in fact was not on the road, but somewhere off the side of the road. A reasonable person acting under similar circumstances would not have driven while being drowsy and inattentively. So Traveler breached his duty to exercise reasonable care while driving. Tom, being in a field by the side of the road, was a foreseeable plaintiff who could be injured by Traveler's negligent driving, because as a result of this negligent driving, anyone who was walking anywhere near the road arguably could have been hurt or injured. Thus, Tom will prevail because Traveler was negligent in going off the road. Let's look at the other three options. B, yes, because Tom was in a helpless condition. Tom's condition is irrelevant. Here, it's very interesting that they mention the fact that he was intoxicated. The question tries to trick you into believing that his condition is relevant to the fact pattern. The reality here is that we have a driver on a highway or on a road who then veers off the road entirely. So regardless of the condition of the individual off the road, the driver would have struck him nonetheless. So the intoxicated state of the individual literally plays no role in the injury, but for the fact that he likely wouldn't have been there if he were not intoxicated. But that's not necessarily true, because people walk through fields all the time. People walk on sidewalks all the time. If the logic here would then follow, then an individual walking on a sidewalk who is struck by an inattentive driver or an intoxicated driver or something of the sort would then arguably be potentially liable for simply being at the wrong place at the wrong time, which is literally what this individual is charged with. Option C, no, because Traveler did not see Tom before Tom was struck. The fact that he saw him or didn't see him, again, irrelevant. It's the issue as to whether the driver was in fact negligent when he left the road. We would present that the answer to that is yes, simply because the fact pattern specifically tells you that he was inattentive and drowsy. Option D, no, because Tom's intoxication was the cause, in fact, of his harm. In fact, that is completely inaccurate. While Tom was present at that location, he was in a safe place away from the road, a place where he would not expect to be hit by a car. It'd be a very different story if, in his intoxication, Tom laid down in the middle of a road and then subsequently was hit then. But here, he is in a place and in a location that should be reasonably protected from the road, so long as the cars on that road drive properly, reasonably, and safely. That being said, none of those things occurred, so as a result, D could not be a possible answer. And as we previously discussed in our analysis, Tom's intoxication, in fact, really plays no role in this question. It is the entirety of Traveler's negligent driving that is the cause. So we're led right back to A as being the only possible answer. Question number 6. Congressional legislation authorizing marriages and divorces as a matter of federal law on prescribed terms and conditions could most easily be upheld if it A, applied only to marriages and divorces in which at least one of the parties is a member of the armed forces. B, applied only to marriages performed by federal judges and to divorces granted by federal courts. C, implemented an executive agreement seeking to define basic human rights. Or D, applied only to marriages and divorces in the District of Columbia. Take 10 seconds. Choose your best answer now. If you chose option D, you'd be correct. Applied only to marriages and divorces in the District of Columbia. The definition and regulation of marriage is within the authority realm of the separate states, not the federal government. The property clause contained in Article 4, Section 3 states that Congress has the power to dispose of and make rules for territories and other properties of the United States. Here, it is important to realize that the District of Columbia is a federal district owned by the United States. Under Article 4, Section 3, Congress has the power to dispose of and make rules for the District of Columbia. Accordingly, the congressional legislation authorizing marriages and divorces as a matter of federal law on prescribed terms and conditions could most easily be upheld if it applied only to marriages and divorces in the District of Columbia. Let's look at the other potential options. A, applied only to marriages and divorces in which at least one of the parties is a member of the armed forces. This would be problematic because obviously one of the parties to the contract or to the marriage would theoretically not be part of the armed forces. And secondarily, members of the armed forces are deemed to be under the coverage of the state under which they are stationed or where they reside. So A would generally not be appropriate. B, applied only to marriages performed by federal judges and to divorces granted by federal courts. Not very many divorces get granted by federal courts. I've never heard of any. And B, applied only, first part of B, I should say, applied only to marriages performed by federal judges. Who marries you is not relevant with regards to what law your marriage is bound by and which law would cover your divorce. So as a result, B is literally as irrelevant as it could be. C, implemented an executive agreement seeking to define basic human rights. Again, arguably, C is not relevant, so we're left literally with D as the only potentially relevant and appropriate answer. Question number 7. Park brought an action against Dan for injuries received in an automobile accident, alleging negligence and that Dan was speeding and inattentive. Park calls White to testify that Dan had a reputation in the community of being a reckless driver and was known as a daredevil Dan. White's testimony is A, admissible as habit evidence, B, admissible because it tends to prove that Dan was negligent at the time of the collision, C, inadmissible because Dan has not offered testimony of his own good character, or D, inadmissible to show negligence. Take 10 seconds. Choose your best answer now. If you chose option D, inadmissible to show negligence, you'd be correct. Character evidence is inadmissible to prove conduct. In a civil case, except where the civil claim is based on sexual assault or child molestation. In this case, Park has brought a civil action against Dan for injuries received in an automobile accident. Since this is a civil case and not based on sexual assault or child molestation, character evidence is inadmissible to prove conduct. As such, White's testimony that Dan had a reputation in the community for being a reckless driver and was known as Daredevil Dan is inadmissible to show negligence. This is one of those questions where so long as you have the right rule, A, B, and C clearly fall out of contention and are clearly irrelevant. We're left with only D as a possible answer. Question number 8. Roofer entered into a written contract with ERISA to repair the roof of ERISA's home. The repairs to be done in a workmanlike manner. Roofer completed the repairs and took all of his equipment away, with the exception of a 20-foot extension ladder, which was left against the side of the house. He intended to come back and get the ladder the next morning. At that time, Marissa and her family were away on a trip. During the night, a thief using the ladder to gain access to an upstairs window entered the house and stole some valuable jewelry. Marissa has asserted a claim against Roofer for damages for the loss of the jewels. In her claim against Roofer, Marissa will A, prevail because by leaving the ladder, Roofer became a trespasser on Marissa's property. B, prevail because by leaving the ladder, Roofer created the risk that a person might unlawfully enter the house. C, not prevail because the act of the thief was a superseding cause. Or D, not prevail because Marissa's claim is limited to damages for breach of contract. Take 10 seconds. Choose your best answer now. If you chose option B, you're absolutely correct. Prevail because by leaving the ladder, Roofer created the risk that a person might unlawfully enter the house. Remember that to establish a prima facie case of negligence, you must prove a duty, a breach of that duty, causation, and damages. The duty of care is a legal duty requiring the defendant to act according to a certain standard to protect the plaintiff against an unreasonable risk of injury. A duty of care is owed to all foreseeable plaintiffs, and the extent of this duty is determined by the applicable standard of care. The basic standard of care is a reasonable person acting under similar circumstances. In this case, Roofer left a 20-foot extension ladder against the side of the house while Marissa and her family were away on a trip. A reasonable roofer would not have left an extension ladder next to an upstairs window to an unoccupied house overnight because a thief could easily use the ladder to break into the house. Roofer breached the duty of care owed to Marissa and this negligence was the cause of the jewels being stolen. Accordingly, ERISA will prevail in her claim against Rufer because by leaving the ladder, Rufer created the risk that a person might unlawfully enter the home. Let's look at our other three options. A, prevail because by leaving the ladder, Rufer became a trespasser on ERISA's land. In fact, he did not trespass because he was not physically present. The question would present that leaving the ladder itself was a trespass, which in fact arguably a case could be made. But that being said, simply he becoming a trespasser was not the cause of the injury here, nor did he contribute to the injury simply by having left the ladder behind. So for example, let's say that he had left any other item that was not this ladder behind. He equally would have arguably been trespassing, or similarly a case could be made. However, the reality is the reasonableness of the ladder itself against the house leading to an upstairs window is really what the concern is, not just the trespass in and of itself, but the type of trespass. Option C, not prevail because the act of the thief was a superseding cause. Regardless of the act of the thief, the negligence by the roofer still exists, and as a result of the negligence of the roofer, there was a subsequent harm. There was a duty owed, and that roofer failed to act reasonably and, in fact, left a situation that would have been quite dangerous for any empty home. So, as a result, he'd likely be found liable. So, C would not likely be an appropriate response. D, not prevail because ERISA's claim is limited to damages for breach of contract. There is not much of an argument here because ultimately there can be negligence claims on breaches of contract, but the reality is that there is no breach of contract here, so much so as an issue of negligence. The ladder having been left or the ladder not having been left is not a part or a direct part or parcel of any contract. More so, it's simply a reasonable person standard on the negligence spectrum. So D would not be an appropriate response, and as a result, B would be the only correct response here. Question number 9. Assume for the purposes of these questions that you're counsel to the state legislative committee that is responsible for real estate laws in your state. The committee wants you to draft a statute governing the recording of deeds that fixes priorities of title as reflected on the public record as definitely as possible. Which of the following, divorced from other policy considerations, would best accomplish this particular result? A. Eliminate the requirement of witnesses to deeds. B. Make the time of recording the controlling factor. C. Make irrebuttable the declaration in the deeds that valuable consideration was paid. Or D. Make the protection of bona fide purchasers the controlling factor. Take 10 seconds. Choose the best answer now. If you chose option B, make time of recording the controlling factor, you'd be dead on. Making the time of recording of the deed the controlling factor, it would fix the priorities of title in essence, because arguably things would be recorded in the order that they were filed, as reflected on the public record, as definitely as possible. Any subsequent purchaser would just need to search the public records for the property being considered to determine who recorded first, and as such, who has priority of title in the property. Since there would be nothing else to consider outside of the time of the recording, this option clearly accomplishes the goal of fixing the property of title as definitely as possible. Now, if you look at option A as a potential option, eliminate the requirement of witnesses to deeds. This actually works contrary to the intention. At the end of the day, what this very well may do is cause a spike in fraudulent deeds that are in fact presented and or filed. C, make irrebuttable the declarations in the deeds that valuable consideration was paid. Sure, the valuable consideration is important and is necessary, but that being said, the key issue here with regards to clarity of title is the timeliness of that filing of title and ensuring that there's a proper timeline in the recording of title. So without question, B is a significantly better answer. D, make the protection of bona fide purchasers the controlling factor. Again, we're back to a situation where if there is an issue with the with the chain of title previously, and now we have a statute that protects bona fide purchasers. Arguably, you would have a situation where transfer of title occurs improperly to another individual, and that individual sells to a bona fide purchaser, and the initial individual is left without a property any longer. We have that situation in the elderly community quite a bit now in many states, where people literally engage in improper deed transfers and then move forward in selling their property. The law generally does not protect that type of behavior. As a result, B would be the only and best answer here. Question number 10. Alex and Sam were arrested for holding up a gas station. They were taken to police headquarters and placed in a room for interrogation. As a police officer addressing both started to give them the Miranda warnings, prior to the questioning, Alex said, "Look, Sam planned the thing, and I was dumb enough to go along with it. We robbed the place. What else is there to say?" Sam said nothing. Sam was escorted into another room, and a full written confession was then obtained from Alex. If Sam is brought to trial on an indictment charging him with robbery, the fact that Sam failed to object to Alex's statement and remained silent after Alex had implicated him in the crime should be ruled A, admissible because his silence was an implied admission by Sam that he had participated in the crime, B, admissible because a statement of a participant in a crime is admissible against another participant, C, inadmissible because under the circumstances there was no duty or responsibility on Sam's part to respond, or D, inadmissible because whatever Alex may have said has no probative value in a trial against Sam. Take 10 seconds. Choose your best answer now. I hope you chose option C. We've seen questions like this before. C, inadmissible because under the circumstances, there was no duty or responsibility on Sam's part to respond. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that very statement. Hearsay is generally inadmissible, remember. A hearsay exemption is admissible because it is not hearsay under the federal rules of evidence. One such exemption is an admission of a party opponent, which is a statement by a party or by someone whose statement gets attributed to that party offered by the party opponent. A vicarious party admission treats the admission as made by the party opponent. One form of vicarious party admission is an adoptive admission, i.e., a non-party makes a statement and a party indicates he believes it is true and adopts as his own statement. Here, Alex blamed Sam for planning the gas station robbery. Sam did not say anything in response. Alex's statement cannot be attributed to Sam because it was reasonable for Sam not to respond under the circumstances. Sam was in police custody and in an interrogation room. Sam was also being read the Miranda warning. Sam could reasonably choose to stay silent instead of denying to Alex's accusations. And Sam's silence would not imply an admission of Alex's accusation, nor would it imply an exception. Thus, Sam's failure to object should be ruled inadmissible because under the circumstances there was no active duty or responsibility on Sam's part to respond. Let's look at our three other options. A, admissible because his silence was an implied admission by Sam that he had participated in the crime. Please recall the scenario here. The individual is in police custody. There's no duty for him to respond to any of the questions. He's not required to. So his absence in responding or his absence in denying a statement made by someone else, his silence in response to that statement cannot and should not be legally held against him. Option B, admissible because a statement of a participant in a crime is admissible against another participant. While this may arguably be true, the question isn't in fact asking this. What the question is asking is, can the defendant's silence in response to the admission be held against him? That is a very different question, and as a result, B is a bit of a trick response, which would be an inappropriate one at that. Or D, inadmissible because whatever Alex may have said has no probative value in a trial against Sam. Well, that is completely inaccurate. Obviously, any statement he could have made could arguably have some probative value. The real reason here is, again, this is not the question that's being asked, is why D is not an appropriate response. The question here that's being asked is as to the silence of the individual, and can the silence be deemed admissible? Here, this answer D, if you look carefully at the response, presents that it would be inadmissible because whatever Alex may have said has no probative value in a trial against Sam. The issue here is not what he said, it's the response of the other individual or lack thereof that's in question. So as a result, C would be your best answer.